Welcome to the judge presentation. Today we have Sean from New York, or I should say New Jersey, or I don't know. How do you introduce yourself, Sean?
Generally, I would say from New York. Yeah, I'm currently hanging out in New Jersey, but I work in New York, and I generally live in New York.
Were you born in the area? I know a lot of Americans move so much that it's hard to say, but
actually, I was born in New York City. Yeah. I was born in New York City and always lived, for the most part, in and around New York City, except for a few years in Ireland, a few years in Delaware, but mostly the New York City area.
Is it true that being born in New York makes you arrogant, or like growing up in New York?
No, that's just me. That's that's.
Well, in general, I mean, in the U.S., there's this perception that I came across that people say, "Oh, those New Yorkers, they're never happy. Nothing is good enough, and because they had the best thing of the best in New York City and everything."
I mean, there is a little bit of that. You get a little spoiled in New York because it's a type of place where you're like, someone could be like, "Hey, you want to go get Ethiopian food?" And if you're in the Midwest, people would be like, "No." In New York, someone's like, well, which one of the Ethiopian restaurants should we go to? Because, this one's not as good as this one. So I think it's more along the lines of their standards kind of got pushed really high. And so, that's kind of what they're expecting.
I thought, I mean, traveling across the U.S., you totally get it. But you go from the land of plenty to where is the nearest place where I can eat to back to the West Coast, and then then they will ask you which style of sushi do you prefer, and today being Wednesday, this place is doing this. Yeah, great. So you're currently with Frankfurt. Is it Frankfurt Kurnit, or do you say FKKS? What's the brand?
To be perfectly honest, both. I mean, people refer to it as FKKS, or people refer to it as Frankfurt Kurnit. Mostly nobody ever says the full name.
Have you ever considered opening an office in Frankfurt, Germany, so people will stop asking if you're a German firm?
Well, see, we kind of like the confusion, so I think we're gonna stick with it. Right now, New York and LA are the office locations, but Frankfurt's beautiful, so I wouldn't mind.
How big is the firm? Is it a few hundred people, 500? 3?
No, actually, we have so we're what would you consider in the U.S. a boutique. We have approximately 100 attorneys, split between our two offices, and the entire firm is focused on the media industry. And so it's film, it's television, it's advertising, it's publishing, and I'm one of the co-leads of the interactive entertainment group. So it's a really great mesh for what the firm does and what it focuses on.
But what's the story of the firm? How old is it? Is it from the 70s? Is Mr. Frankfurt or Mrs. Frankfurt still around?
Mike Frankfurt is still around. Yep. He's in his 80s now. He still comes in. He's like the heart of the firm. He, walks around and, still has an amazing book of clients, but, he walks around and he makes sure everybody's doing well. The firm has been around for now about 45 years or so.
So that puts you in the same category probably as Kim and Chang that Brian works at. I think Kim and Chang is now a huge one, but they also have Mr. Kim still in the firm. And I think he was talking about pretty much the same timeline that was there. Okay. And you were born... Go ahead.
I was just going to say, our firm actually has made a point of not becoming huge. It's actually turned down many opportunities to join larger firms because the firm really likes its style of practice and likes the kind of agile aspect of being kind of like 100 lawyers, because we can go up against anybody, but we also can represent like certain clients that say, a 500 or 1,000 or multi-thousand person firm can't represent because they're like, well, our clients need to all be huge to pay our rent. So we kind of actually curated and made decisions to be the size that we are.
Oh, that sounds familiar to some of the other firms that we discussed, where there's a certain optimal size where you're powerful enough, you're great, you can cover the whole thing, but you're not being locked into this machine and factory, and then that becomes conflicting. And the firm started as a media, so publishing, or is it the book publishing? Is it the newspaper publishing, advertising?
So it started more on advertising and entertainment. So some of the early clients that the firm had were, some of the, continue to be some of the biggest Hollywood actors and directors and writers. And they were working on, they were kind of the un-LA firm. At the time, they were only in New York, and they were for actors or, Hollywood people that didn't want a Hollywood firm. They didn't want that, they didn't want what went with a Hollywood firm. And so, we represented them, in a New York style. And also advertising in New York is kind of the hub of advertising in the country. And so the firm initially kind of focused on those two metrics, and from that expanded out into, some of the other sorts of entertainment areas like book publishing. We do represent a lot of media outlets, but those things come up more in like defamation claims or advising them on, on kind of where the line is for copyright.
Mm-hmm. And your involvement with the video games industry, when did it start, or how did you go around it? Is it some people move from technology to video games, where games are using technology and they need a tech lawyer who can understand it? Some people go from the content, so they represent, let's say, someone who owns an IP, and then they move into video games, and then that comes together. Some do transactions. So for you, where did it come from?
So it's interesting. I'm one of the few lawyers in the industry that I know that actually decided to be a video game lawyer and then did it. It wasn't a kind of slid from one area to another because I happened to be working on something that had some video game issues. So my history basically is, for the first about 6 years of my career, I was an intellectual property litigator. So I was dealing with copyright, trademark, false advertising, defamation, really focused on, on IP and litigation. I decided that I really like the strategy aspect of litigation. I like the chess game of basically outthinking your opponent, and, putting together a legal argument, finding the case law to back it up, and getting there and presenting it. Because I'm an actor at heart, so getting up there in front of a judge, in front of a court, was something that I really enjoyed. But I realized that I didn't like most litigators, and I didn't like the way that a lot of people practiced. And I felt that they were being obstreperous for the sake of being obstreperous, instead of trying to find the right path to a solution that would work for the clients. And so I decided, I was like, I'm done with litigation. I'm going to go move into something else. And so I actually left the firm that I was at, and I decided to start my own firm. And this was almost 20 years ago. I had no clients in the video game industry. In fact, I had no clients at all. But I had an office, I had a phone, I had a computer, and I spent a few months trying to focus on what area of law did I think there was an opportunity to become an expert in. And, and that was because a partner that I had worked with had always said, if you want to be a success in the law, find a niche and become the expert. And that had been the path that he had found worked for him. And so I spent about 6 months looking at all the different technologies, and, I looked at different areas of entertainment. I wanted to use the IP background that I had because I did like that aspect of law. And I ultimately decided that, video games were something that nobody seemed to be focusing on. And there were very few firms, there were very few lawyers at all that were doing it. There was very little research and writing. And so I decided, I was like, I'm going to be a video game lawyer. And people actually thought I was insane. They said, you're going to ruin your career. This is not an area of law. And, I said, no, I think it is. And I then basically started holding myself out as a video game lawyer. I started, reading everything that had been written on it. I started writing articles. I started pitching myself to different industry events as a speaker, meeting with reporters, meeting with, clients, and, steadily built that practice up to the point where all of a sudden people in the industry were like, oh yeah, Sean's a video game lawyer. And my name got out there. People, if I didn't show up at an event, people were calling me like, "Where are you? How are you not here?" And that was 20 years ago. And it's only gotten more interesting since then.
Did you get a chance to work with GT Interactive, the New York-based publisher?
I do not get a point. I don't work with them. I do work with. Well, I get to work with most of the major developers and publishers in the U.S. I work with, a little example. I work with Take-Two. I work with Square Enix. I work with Epic, Wargaming. We work with probably 150 or more video game companies at this point, and they range from startups like we've got several clients that haven't even put out their first game yet to the largest games in the world.
I remember GT because they had an office in Manhattan. So that was one of the few cases where you could actually walk up to the publisher's office, and it wasn't a great office, by the way. It was like pretty crappy office. But outside of Rockstar, is there anyone based in New York? Is this happening? Like, are people setting up studios because quality of life is incredible, or it's too expensive still?
So, yeah. There are people. There are companies setting up studios in New York. There are companies setting up studios everywhere, obviously. But outside of Take-Two, there's not really that mammoth sort of video game company in New York. Now, one thing you see a little bit more in New York is, since most of the television studios, basically, ABC, NBC, all that sort of thing, are kind of headquartered in New York. You do see this, and most of the advertising companies are headquartered in New York. You do see this ecosystem of game development happening in New York, but most of the development itself is happening outside of New York because of the cost of rent. And if you're going to have a team that's building a game, New York City is probably not your cheapest place to have them located.
Would you say right now, I'm totally out of the depth here, but is it comparable to San Francisco? I know that people complain historically about San Francisco rents and prices.
I think, New York, San Francisco, LA, they're all expensive. I think New York is probably slightly less expensive than San Francisco, from what I understand. But it's also not quite apples to apples. Mm-hmm. The type of, you don't have houses in New York City like you do in San Francisco. Yep. Even if they're kind of row houses, you don't really have that sort of same thing. The brownstones in New York City, are just untouchable for under $10 million. So, it's really much more apartments, versus, where in San Francisco, you can legitimately have a house, in either the outskirts of the town in some way or another.
Yeah. Okay. All right. So you're currently practicing in transactions, in negotiations, in advisory role, covering the whole thing. Do you do litigation? Do you still go to court on behalf of the games clients?
So everything. We're really industry focused, not necessarily one silo within it. Mm-hmm. So we feel like we keep our pulse on what's going on in the industry in general, and so most of the time it's transactional work, or it's regulatory or advisory. We literally are sometimes are part of the design team of games, where we sit down and work with the designers and give them little tweaks that might be able to alleviate or mitigate a potential risk area. But when it comes to litigation as well, we have, right now we're, I think, working on probably 5 or 6 different litigations at the moment. Some involving clone claims. Mm-hmm. Others are involving loot box, issues. And in those cases, I'll work with one of our litigation partners because, I'm not full-time performing litigation services anymore. So, I'll work with one of my litigation partners who will be running the day-to-day of the case, and I'll bring my industry knowledge or game knowledge and help strategize on the best ways to kind of argue different issues. So, So it's pretty seamless because we have those people here at the firm, and they're very knowledgeable about technology and games. But I'll come in and advise them.
How much of your work is US focused? Is it that let's say you're the firm that people go to resolve issues in the US or based on American law, or is it more of, when you say you're a part of the design team, I would imagine that mostly the games are global, so whatever feedback you're giving is going to apply to the global rollout of the game, that this is what generally will cause you trouble if you do this in the game.
Right.
So what's the split for you?
So I would say, predominantly the advice we're giving is U.S. because we're obviously U.S. lawyers. But depending on what the issues are, we are pretty well versed internationally on what the norms and mores are of the industry. Now, again, I wouldn't say that we're the only firm in the U.S. that knows this stuff, and we've got wonderful colleagues, many of which but there's certain areas that we probably know better. Use the example microtransactions, loot boxes. We've actually done research in literally every territory in the world. Places like Wallis and Futura, which is a small island. I'm not even certain there's many people there, but we've done the research on microtransactions and loot boxes, and we've done it literally everywhere. And so clients will come to us for that sort of expertise, because in that case, we can help their design team almost everywhere understand where the risks are. Now, if there's something that's so risky, we're going to bring in one of our network of international firms that we work with, and we'll get their advice on a specific issue. But quite often we're, to use kind of a football, an American football metaphor, we'll be the quarterback handling the entire program, and then we'll be, working with or controlling the different players in different jurisdictions. But, predominantly I would say that at least, 75% of our work is going to be focused just on U.S. issues. But that could be for clients all over the world, because we have them everywhere.
Yeah, so that's my second question. What about the clients? Are you talking about, like, do you work with international clients handling the U.S. issues, or American clients handling American issues? Because that's a big market, but also you've got a bunch of industry companies as well as a bunch of issues that are specific to the U.S. So for you, would you say among your, let's say, 100 clients, take 100 clients, how many of them will be American?
I'd say probably... from say 100 clients, there's probably going to be about 60 or so that are American companies, and then the rest of them are going to be from somewhere internationally, and in those cases, predominantly what we're doing is we're advising them on the U.S. market, and given the size of the U.S. market, not to say that the U.S. market is the end-all be-all, but for most games, it's a pretty significant portion of their international market. We may be advising, advising companies on one of their kind of most important territories. So, and those particular clients can be anywhere, in Asia, in Europe, Africa. We have clients. The only place we don't have any clients is Antarctica. So.
Do you ever run into the conflict of interest clauses? I was wondering, like, with the size of the firm that you have, what are the chances that a company will come to you and say, hey, we would like to have your opinion on this, but could you tell us that you're not representing this firm? And then I thought, okay, industry is pretty small. So if you look at any major country, there are competing groups. And I would imagine, I don't know, but I would imagine if you work for, let's say, Tencent, there'll be, I don't know, NetEase group of friendly companies that would say, oh, no way, or just build a wall and going to work with you, but not with this guy. Or how do you handle this? And generally, how does it happen in the games industry? Are people as friendly as we are led to believe?
For the most part, yes, they are. It's interesting. The conflict stuff does come up quite a bit, but it's not as problematic as you would think for an industry that really isn't that large. So, it's funny because this morning, once I get off of this, I have to go deal with a conflicts issue because I literally have one client that reached out to me and they're like, "We're going to do this deal where we're going to we're going to create an experience based on the IP of one company, and we're going to work with this other company to actually build it." And I'm like, "Well, this is wonderful because all three of you are my clients. So there's going to be we're going to have to figure something out here." But I would say, at least as a firm, our firm has always stayed away from representing like Hollywood studios, which is actually because we represent so many content creators in the entertainment industry. And that was one of the reasons why I joined the firm, was because like I knew I can negotiate against Disney or Universal or Warner Brothers or any of the other ones for these large IP holders without fear that I'm going to be conflicted out. In fact, I mean, the real problem that has come up is some of those studios have wanted to hire us, and we're like, we can't, But interestingly enough, when the conflicts do come up, most clients have been willing to kind of waive the conflict. Now, obviously, I wouldn't be representing both sides of any deal, but for example, I had one of the major publishers here in the U.S. that I've worked with for now more than 15 years. A client of mine reached out to me and were like, "Oh, we're going to do a publishing deal with this publisher," and they asked me, "Can you represent us?" And I said, "Well, I represent that company in a lot of different areas. Usually, I'm not doing their publishing deals, but I represent them in many, many different areas." And I'm like, I really don't know, what they would say to that, because I'm so tied into them. But I reached out, because I always do, and I said to the client, this is what my other client would like. And initially, the client said, "Well, Sean, we can't have you do that because you're our games guy. You're the guy." And so I said, "I totally understand. That's kind of what I thought, but I obviously have to ask." And interestingly enough, about a half hour later, they called me back and they were like, "Actually, you know what, Sean? We'd like you to do it because we know that you know what you're doing. You're not unreasonable as a person. And so we both want this deal to happen. So we'd like you to represent them because we know you're really going to focus on the important aspects of this deal. You're going to, your turnaround times are quick. They basically said, they're like, if we have to have somebody on the other side, we prefer it to be someone we know is reasonable."
Yeah, so that's what I was about to say, is that if you wouldn't represent them, there could be a different lawyer who would do something that maybe would not be so well fine-tuned to finishing this deal, but more of establishing themselves or, looking at the issues that don't really matter.
Or someone that doesn't know the industry, in which case they're focusing on the wrong points.
Well, I mean, one of the things that you mentioned, I think a few other firms also mentioned that representing huge clients is more of a disadvantage than advantage, in the sense that if you represent Google, okay, what are the chances that you're going to go against Google if some of your games clients have an issue? Look at Epic, would they work with a law firm that represents Apple, that represents, Google? Yeah, that kind of blocks you a lot of different pathways around it. Yeah, great. So for the lawyers who start in the video games industry or who would like to join the industry, what would you say is the defining quality? When you look at young lawyers, and we'll have 4 teams, and many more next year and the year after, what do you think makes for a good games industry lawyer, and not just a good lawyer?
Yeah, I was, sorry, that's a great question. When we hire lawyers, and my partner Greg and I, hire for our team, with some frequency, we're always looking for really motivated people, and I don't just mean motivated to practice law, but motivated to do what we do, which is video game law. Because, we always kind of say we can teach you the industry or we can teach you the law, but we can't teach you both. You have to want to do it. You have to be interested in it. The number of times a client or a contact kind of be like, "What games are you playing?" if you can't answer that question, you shouldn't be in this industry, because you have even again, you should be playing lots of things, even if you don't love every one of them. I mean, every game, everyone has different sorts of interests, but you have to know what the features are. You have to know how those games are played, because then you can't really represent somebody if you don't understand what the product is. So, I look for people that are interested in games. When it comes to kind of what sort of experience they have, I find that either, intellectual property background is great, because there are so many issues of IP that, that are dealt with in games. Litigation can be a good background for certain aspects, because much of what we're doing is advising clients on potential risks, or whether or not one game is potentially too close to another game. So that can be useful. Having a lawyer that's knowledgeable in technology agreements and/or IP license agreements is hugely important, because much of those skills are transferable to a video game license deal, a publishing deal, a development deal. Understanding what those issues are, we can easily teach you the nuances. So it's really a lot of that. But it comes down to, for anything else, it comes down to how much do you love the industry? Are you as nerdy as the rest of us? That's what we want to see.
Yeah, I don't think you can replicate the passion or the interest. And if someone tells you, have you played Fortnite? What do you think about this or that? It's hard to imagine someone having an opinion about the legal aspect of Fortnite without experiencing it. Or same for Minecraft, Sure, or same for VR. Even the something like a tabletop simulator, which gives you a 3D version of the board game from the real life. To understand the legal issue of allowing me to recreate someone else's board game in 3D and then share it on Steam, it'll take an effort to actually play it and run it and understand it from the different sides. For the teams,
well, especially since some of the things we're dealing with have never been done before, and so you really have to think through the legal aspects, and the law tends to be reactive, not proactive, and so quite often there's almost nothing to go on when you're advising a client. So you're making analogies to some other area that at least has some body of statutory or case law that you can look to.
I think it's happening more and more often as we see certain things in the game and people are just like, okay, is there any area of law that deals with it? No? Okay, what's the next big thing? Okay, music? Is it performance? Is it a theater? Is it film? So yeah, looking outside. What would be your advice to the teams that go in front of you? Would you say that, since you've been a litigator and you have intimate court experience, what would be your advice to those teams in the sense of digital presentation? Now it's the first time they're going to do it digitally. They're not going to be able to stand up or they can wave hands, but probably not really standing up. It's harder for them to understand you as the judge. Are you happy? Are you nodding off? Are you like, what is this face? What does it mean? And since it's not the real courtroom, you wouldn't be able to say, for example, I know, and then everyone is like, what? So you'll have to, raise your hand or do something. So it becomes more pronounced. And I think that the mistakes could be bigger if people just not notice something, or they keep talking at you and this is your angry face, but he's smiling. He's like, actually, yeah. So what would be your advice to the teams in terms of how they can be better at this hearing?
Sure. I mean, well, generally if someone is nodding off, that's not a good sign. I will say it's seldom that people are asking me, kind of what happens if someone, doesn't hear me or, doesn't, given the way my voice tends to boom, I don't usually have too much of a problem breaking in and asking a question if necessary. But it is something that's interesting, and the doing court hearings via Zoom or WebEx or whatever comes with lots of challenges. The least of which are don't be a cat when you're doing your presentation. But I think what really becomes important is to, as best that you can, let the passion you have for your argument come through in your voice, and even your facial expressions, because yes, you can see hands, but it is not a place where subtle gestures are going to come across. You literally need to move your hands up next to your head, for them really to be noticeable. So I think for the interesting thing for some students, this is easier because there's almost a little bit less nervousness of what you need to do with your body and how you need to hold yourself when you're performing your argument through a video conference system. So I think really what it comes down to is I always tell everybody, I'm like, know your argument, be passionate about your point, and it doesn't mean you're right, it doesn't mean you're wrong, but I've seen people win arguments because of the tone of their voice, the passion that their argument has relayed, the confidence that they exude.
So
and, in my mind, that's really the best way to do it.
So basically, if they will make some errors, then make those errors on the side of being too emotional, being too much there in the theater, as opposed to just being reserved.
Right, and also remember, the fact is, you should always have your talking points. So even if you go off, for a moment in another area, or a judge asks a question, and you get there and you're emotional and you say your point, just make sure you go back to your talking points. And they always say, if you don't have the law, kind of argue the equities. If you don't have the equities, argue the law. If you don't have either one of them, be passionate.
Okay. Well, I mean, sure, very good. So we'll see how they perform. It's a big open question for all of us. We will have the presentations of the teams. I think it's okay for all the judges to watch them. It's just basically, some conversations why they decided to do this. Maybe not. Maybe that could influence your decision, because some of them will talk about the background. I think maybe that's a bad idea for us to let the judges watch those, because that could make you think, oh, this guy is really great because he loves the game that I love, so I already feel confident in him. So yeah, but what I can say is that all of the teams are great. They're the top of all the teams that have applied. They've done a great job with the submissions. We couldn't tell which country the submission is from after we assigned some numbers, and that was a good sign. That means that they're all at the same level. It doesn't matter where they come from. And I think a few of them already are working with video games industry matters. Some of them are transitioning there. But I'm quite sure we'll see some of them in-house or at the law firms in the future. So that'll be a great little test in 3 weeks to, see that competition unroll and maybe close as we can to having a real litigation of a games industry matter.
Well, I've sat in on pretty much every one of the competitions over the last few years at the event, and the teams have always been spectacular. So I expect nothing less this time when I'm a judge. So
to the teams who will watch this, Sean has seen it happen before, so you have to realize that he's seen other teams make certain mistakes, win this or that. And he will not be overreacting to whatever you say. So I think that you can count on the fact that he'll bring the experience of the previous competitions, and you'll be judged at the same level as those have been judged. And that kind of gives you the tradition from the previous competition. So we cannot say, this year's competition is really tough because we have those judges that just came in from the cold and they were very angry and they expected this. No, you've seen them all. So, you can confidently say you guys are as good as last year, or maybe even better. Oh, maybe not as good. I don't know.
Definitely. Hey, I work with some of the lawyers now that, I first met when they were competing. So...
So hopefully that also continues in the future. Thanks a lot, Sean. I'm gonna See you in 3 weeks when we have the hearings. May the strongest team win. And if you want to connect to Sean, then his link will be in the description of the video. And now it's time to say thank you to all the wonderful law firms and games companies that you right now see on the screen who help us run the summit, and in particular this challenge. And see you guys in the next presentation.